Well, while we're waiting, why don't I kick off with a few general things? Lisa, our new commissioner, is en route. I've heard she's in a cab from the station right now. Nick Hopkins, who was the commissioner for property, family and trusts um, uh, for 10 years, left earlier this year. And Lisa is the new commissioner since September. So she's getting up to speed with all our current projects, just as we've kicked off the 14th programme of law reform. So as well as continuing chancel repair, our team is continuing its work on commercial leasehold. We have a project just started on housing estates, looking to extend the right to manage to freeholders of houses. There's a project due to start soon on ownerless land on a street in Bonficantia, which is a very obscure area of law like this, but unlike this, it affects so many areas and crops up with alarming frequency. And when it goes wrong, can really go wrong. And we have projects on kinship care and burials and cremation still continuing. Don't think I've forgotten anything, have I, Rita? So that will be keeping the property team busy for the time being. I don't know all of the projects the other teams are doing, although the criminal team's large project on appeals is continuing towards a report. I'm just going to check and see if anybody else has joined online. Yes. Can anybody who's online give me a thumbs up if you can hear me okay? And also if you can see the slides up on the screen. Brilliant, thank you. So hopefully Lisa will come and we'll join in. But as we're going through, if anybody has any questions about what we're talking about at that moment, do stick up a hand, or online stick up a hand, and we can pause and deal with it. It's probably better to deal with any questions about individual slides as and when they come up. I won't be talking for more than 45 minutes, an hour, so there'll be plenty of time to discuss anything anybody wants to discuss at the end. Set my timer going. Right. Well, if I start very quickly, and we'll take a break when Lisa gets in. There we go. So we currently have a consultation open on chancel repair liability. It's open until the 15th of November, when you will no longer be able to, on the 16th, you'll no longer be able to go to our website and respond to it online. That said, we don't have a fixed date for the report yet. So if something goes wrong and you just miss it, it's worth emailing and I will pick it up. Well, as it's a rather niche area of law, I'm not expecting to be inundated with responses. So it is fine if you want to send views by email, although obviously the preference is to use the website and fill in answers to the questions we've got there. You don't have to answer every question. Some of them are technical, some of them are about experiences in practice. So answer the ones that you can. Moving on very briefly, for those, if anybody's unfamiliar with what chancel repair liability is, very briefly, the chancel is the eastern end of the church. It's usually separated from the main body of the church by a step. And in old churches which missed the Reformation, you may find there's a rood screen, a large wooden screen between the chancel and the main body of the church. And chancel repair liability, very basically, is a liability to keep the church in good or substantial repair. Unfortunately, that can be rather expensive because we're only talking about old churches, pre-16th century churches, and that means repair will probably involve stonework, lead, roofing oak. It's difficult to say how much it could in theory cost because very few cases arise. But the last one to make headlines, which was Mr. and Mrs. Wallbank and the Aston Cantilever Church, it cost them in the end £190,000 plus VAT. So it is potentially a very hefty liability if it arises. Moving on. Chancel repair liability, well, originally it applied to parish priests, and that responsibility has been taken over by parochial church councils in England and the representative body in Wales. But it binds an interesting assortment of people and organisations, including, for example, Eton College and a number of Cambridge colleges. But this project isn't a free-for-all. We didn't take it on to look at chancel repair liability in general. We are interested in land. It came out of our work on land registration. And so we are interested in any land which carries the liability, in anybody who, by buying a piece of land, might incur this liability. And I'm going to talk a little bit later about how it's arisen, what its nature is. So I've put on this slide our aim. We want to ensure that a purchaser of registered land will only be bound by the liability if it's noted on the Register of Title. Fine. Those of you familiar with land law, however, might say this. Well, there's a Land Registration Act. It generally provides that purchasers aren't bound by nasty things on land unless they're registered on the title. So is there a problem here at all? And if you're familiar with land registration law, this is the relevant provision that you'd have in the back of your mind. Section 929 deals with transfers of registered land, not just transfers, sales for value. And on a sale of registered land, it says once you've completed it, which means registering yourself as the new owner of the land, any interest under the disposition is postponed to your interest, which is taken to mean it's not binding on you. So the previous section said an interest affecting land isn't binding on a purchaser unless it's protected, and there are two ways of protecting it. Usually, one is, the second one on the list is to enter a notice. In other words, to put it on the Register of Title so that a purchaser can see that it's there. But the first applies where the interest is overriding, which just means it's listed in the Act as being overriding. And if it's overriding, then it doesn't need to be noted on the register in order to bind a purchaser. So in general, the Land Registration Act lists interests as overriding if they're relatively short-lived, if they're quite easy to discover by inspecting the land. For example, the best example is a short tenancy. A tenancy for 1 year. If you're buying the land, you should go there, you'll meet the tenant. They'll say, hi, I live here, I've got a tenancy, and everything is fine. But certainly under the older law, there were a few nasties hidden in the list of overriding interests. And one of them was chancel repair liability, which was listed as overriding under the Land Registration Act 1925, and initially listed under the 2002 Act as well. But that was subject to a sunsetting clause. So from the 13th of October, chancel repair liability ceased to be overriding. And the thinking was, well, if it's not overriding, then the only way of protecting it is to register a notice. And if there is no notice, then if somebody buys land burdened by a chancel repair liability, they won't be bound by it. It'll be postponed under Section 29. So where's the problem? Well, things become a little less certain once it's noted that although just 2013 has passed, there is still quite a market for chancel repair liability searches and insurance. Insurance doesn't typically, as we understand, doesn't cost very much. But it's it's a bit curious to us that this market exists, because surely you look at the register, you see there's no chance of repair liability, there's no reason to get out insurance. And in this project, we've been trying to find out why that's the case. And digging a little bit into history, the Law Society produced a paper. I didn't publish it. There is a paper floating around where they said that possibly chance of repair liability isn't an interest in land and is not governed by the Land Registration Act. And that paper was seen by Land Registry, who thought the arguments were somewhat convincing. And so if you look at Land Registry's guidance on chance of repair liability, it notes that there's an argument that it's not an interest in land and so isn't subject to the Land Registration Act. And if that were the case, then the Act wouldn't require it to be registered. And you might be bound by it even though it didn't appear on the title. So that was our way into this project. I'll pause there briefly because Lisa's coming in. Hi, Lisa. We've got a few people online who can hopefully hear me through the computer. Lisa is the new commissioner.
Hello there, very nice to meet everyone. Sorry I'm late, casualty of the trains.
I don't know if you want to say anything in general at the end of the project. Okay, so let's look at the Land Registration Act in a little more detail and explain why there might be a problem here. I've put up section 29 again. This is what it actually says. It says that when there's a sale of land, its registration of registered land, its registration will postpone to the interest under the disposition. That's in the case of a sale of a freehold, that's the freehold title that the purchaser of land is getting. It will postpone any interest affecting the estate immediately before the disposition whose priority is not protected. So it relies on this reference to an interest affecting the estate. And then if you look at the definition of notices, what it is to enter a notice later on, a notice is an entry in the register in respect of an interest affecting a registered estate. So this phrase, it appears in other places in the Act too, but it's a key phrase for the purposes of these provisions, because if you want to know what it is that you escape from, it is an interest affecting an estate, whatever that is. And there's a definition hidden at the end of the Act. In this Act, references to an interest affecting an estate or charge are to an adverse right affecting title to the estate or charge. Now, in the consultation paper, I won't go into great detail, but we explore some arguments that the Act only applies to property rights, not personal rights. So, well-established interests in land, if all somebody has is a personal obligation against you, because, for example, you've signed a contract with them and you've breached it, that's not the sort of thing you can register on the title. We're not entirely certain. The Act does deal with a lot of different kinds of things, including things like local land charges, which are usually statutory burdens. But in general, we think there is an argument that it only deals with things that can be identified as actually interests in land. The reasons for that is, well, I mean, it's talking about adverse effect not on the owner of the land, but on the title. It looks like it's dealing with things that detract from your title to land, in the way that if I buy a property and somebody's right of way goes across it, their right of way detracts from my title to the land because I don't have free use of it. I can't block the right of way. My title is limited by their rights. So we think that's the sort of thing it's dealing with. Another hint that that might be the case is that section 29, which we've looked at, is dealing with interests being postponed to one another. And that looks like it's a concept of property law. The principle being that once you've given an interest in land, that limits what you can give to someone else. And so it matters in what order you give interest in land. And section 29 effectively works by imagining things have been given in a different order, depending on whether or not they've been protected. So we set ourselves a question. Is chancel repair liability an adverse right that affects the title to land? Is it an interest in land? Is our big question in the technical part of the paper. So I'm going to talk you through that a little bit for time. Things get a little bit technical, but there's some fun details too. But please, either online or in the room, stop me if you want me to stop and explain anything, or if I'm covering anything too fast. I want at the end to get onto the law in Wales in particular, because there are some very interesting aspects to the law in Wales so far as chancel repair liability is concerned. Rita, you can let me know if anybody sticks their hand up online. So, the history and nature of chancel repair liability. Well, we know quite a lot about what it was initially. It's an obligation on parish priests, who were known as rectors or parsons, and were given, when they were appointed, a set of property, which I'm going to get onto, which provided a living for them. And they had the obligation to repair the chancel. Now, ecclesiastical law has changed. Those obligations have passed to parochial church councils in both England and Wales. I was wrong earlier, but but something happened in the 16th century, and as a result of that, some other people became liable for chancel repair. And we are particularly interested in landowners, as mentioned. So
you were right. You were both right and wrong. So Matthew Chinnery and the Church in Wales. In terms of the civil law, they're right. The obligation is passed to the representative body. It's part of the constitution of the Church in Wales. The obligation is delegated essentially to the parochial church council. So as a matter of civil law, you were right first time. As a matter of reality, the law advised members of the Church in Wales.
Yeah, I sadly remembered the Constitution also puts it on parochial church councils. That's yes, okay. But either way, the lucky parish priests, they are now not liable for repairing their own churches. So going back into the distant past, before there was a separate church in Wales and Church of England, when everything was branches of the Roman Catholic Church, parish priests, known as rectors, had an obligation to repair their churches. In continental Europe, it was an obligation to repair the entire church. Well, not in areas of Germany, but in England and Wales, responsibility was split. So the parishioners had an obligation to repair the nave of the church, which they would contribute to through church rates levied by the church wardens who do summon a vestry, and the rector, the priest, would repair the holy end of the church, the eastern end. And rectors were given a living to support them. I've put a picture of the rectory up here. It's difficult to classify what a rectory was, but I think possibly the most accurate thing to say was that it was an office or a living. So it involved duties, just as an employee might have duties, but these were not duties of an employment contract. They were religious duties to repair the chancel, to provide divine service, to provide support for the poor of the parish. It came with various rights. You had the chief seat in the chancel. You could rights of burial in the chancel. You could erect monuments sometimes, and it also came with various property. There was glebe land, which was just land you were vested with for as long as you were the priest, which you could farm or you could let and make a profit. You got a house, usually parsonage house or the rectory, and you'll still see houses called the rectory or parsonage around the place. And importantly, you got a right to collect tithes, which was an ecclesiastical duty on anybody who owned land to provide a tenth of the produce of land or a tenth of the animals grazing on land. And initially, tithes were quite valuable. They went down in value, but we'll come to that. So another complication. In many parishes, the priest was not appointed by the bishop. The bishop didn't have a free choice as to priest. A lot of parishes were built not by church funds, but by the local lord of the manor, who gave the land, who built the church, and the law gave them, as a result, a right to nominate the rector. And the bishop couldn't refuse, so long as the person that they nominated was canonically qualified and upstanding. And this right was known as an advowson. Initially, it just attached to the manor, so that the lord would exercise it, and then their eldest son, because daughters weren't inheriting back then, would also exercise it, and that would pass on with the manor. But it became severable so that it could be sold separately, and that created a trade in advowsons. And what happened was that before I go on, just a piece of terminology. If you ever see a reference to the patron of the parish, that just means the person who owns the advowson and gets to appoint the rector. We have some illustrations, if anybody's familiar with Jane Austen. Lots of old landlore turns up in Jane Austen. But for a start, Pride and Prejudice, Mr. Collins, the loathsome character, he's given the rectory by Lady Catherine de Bourgh, who of course is not a bishop. She is a member of the gentry. Similarly, Sense and Sensibility, Edward Ferrars, he gets the rectory of Delaford at the end from Colonel Brandon. Move on. Right, here's where the plot thickens. So, prior to the Reformation, starting in around the 12th, 13th century, a lot of advowsons were acquired by religious houses, monasteries, but also hospitals, nunneries, priories. And they used them to appoint themselves as the rector of the parish, because they were religious persons, corporations, but still religious persons, and they could be appointed. And it was either done as a corporation aggregate, so collectively they became the rector, or they would appoint the abbot as the rector, but as a corporation sole, so the next abbot would still be the rector. And effectively, they became the perpetual, the forever rector of the parish. But the monastery as a corporation couldn't say divine service. So what they do is they just deputize that to one of the monks, who was known as a vicar. The substitute from the Latin vicarius. And the reason this happened is it was a good financial wheeze, because you got the income from the rectory, and you didn't have to give all of that to the person you delegated to say divine service. So traditionally, the monastery took the great tithes, which were corn, hay, wood, and the vicar might be given the lesser tithes, which somewhat foolishly included the products of industry, which became much more important as time went by. So what does this look like? We've got a parish priest. They have their office of rector. They have rights and various property invested in them, but they also have obligations as priest, including chancel repairs. And they were appointed by the lord of the manor. But when the advowson was acquired by the monastery, it could appoint itself. And it can't perform, it wouldn't need the parsonage house, usually. It can't say divine service. Don't know about support for the poor, question mark. But it could delegate functions. So it has its own advowson, the advowson of the vicarage, insofar as the vicar became a permanent post. So it could appoint the vicar, and the vicar would take some of the property and leave other property with the monastery that was the perpetual rector. So on we go. Now we hit the, sorry for people online, you don't need to see my diary pop up. Now we hit the difficulty. Before I go on, can I double check that the people who are online, can you still hear me? I don't want to have cut out. Double check. Okay. Okay, then that'll do. So now we get to the nub of the matter. 16th century, the Church of England splits from the Roman Catholic Church, and almost as soon as that's happened, the next year, legislation starts getting passed by Henry VIII, dissolving the religious houses, against a backdrop of public dissatisfaction with all this property having been squirreled away by the monasteries. Although those upset about the misuse of church property don't get much solace from this process, because it doesn't end in all this property going back to the use of the parishes. It ends in something else. So between 35 and 47, but we're particularly looking at 1539, which is when the greater monasteries are dissolved. A lot of religious houses are dissolved by Act of Parliament, so they cease to exist. Now, as far as the rectories were concerned, all that would have done would mean that the perpetual rector wasn't perpetual anymore. In fact, they were effectively dead. So a new rector could then be appointed. But the Act didn't just say that the monasteries were dissolved. They said their property goes to the Crown. And they didn't just say property in general. They referred to parsonages. So the Acts were interpreted by the courts fairly early on as having transferred the parsonages, the offices that used to be filled by the monasteries, to the Crown, and to authorize the Crown to give it to lay people who weren't clerics, because it was past the Crown that says and decides. So the Crown transferred a lot of these rectories to the gentry. Some went to dioceses, some went to Oxford and Cambridge colleges, some went to Eton, but a lot of them, the majority of them, went to the gentry, and that process was known as impropriation. So chapter 3 of our consultation paper examines what the initial effect of impropriation was. Because if you've only read, perhaps you've read the House of Lords decision in Aston, Cantlow and Walbank. It sounds as if chancel repair liability is just an odd kind of burden on land. If you read it, there's not much. There's not a huge amount of analysis of what it is, but that's how it's described. Chapter 3 of the consultation paper looks back at the older case law, and our analysis suggests that it's not that the Crown just took property and the court then said, okay, well, you can have it, but if you have it, you've got to take a burden with it because that's fair. And so now this land will be treated as if it's burdened by an obligation to repair the chancel. Rather, it looks as if the courts, as far as possible, treated the Crown and then the gentry as if they were rectors. So it applied the whole gamut of ecclesiastical law to them, except we'll go through actually. So rectors, the lay rectors who got this property, yes, established very early on that they're subject to chancel repair liability. The earliest case we found was 1609, but even in that decision, it seems to be taken as an obvious fact. It's not open for debate. But in addition to that, they got the right to the chief seat in the chancel. The freehold of the church and churchyard, often forgotten these days. The advancement of the vicarage, if there was a vicarage. The right to minister to the parish. There are cases where lay rectors said, well, actually, I happen to be canonically qualified. So I'm gonna take on the task of providing divine service, and I'm going to control who can and cannot preach in my parish. That was the Duke of Portland in the 18th century. The right to collect tithes, and also a presumption that tithes were paid to you. So they stepped into the shoes of the priests in having the presumption at law that all land in the parish was subject to tithes, and unless you could show otherwise, it's payable to you by ecclesiastical right. So we think, somewhat tentatively, because the law is very old, that the lay people who got this property were treated as if they were the parish priest, insofar as possible, except for the fact that they couldn't actually do the job of the priest. and they were free to transfer the property to whoever they wanted. And that had certain consequences. So a parish priest could be suspended by the bishop, could be dismissed. The bishop also had a right to say, okay, there's a vicar, but they don't have enough income. No vicar can live on the income that's been given to them. So you as rector need to give them more. That right didn't apply to lay rectors because that was taking away property that had been given to them by the crown. But apart from that, as far as we can tell, they were treated just like parish priests. Now, after
there's a mixture here, I think on the last slide but one, of some aspects which are common law, such as freehold, some aspects which are canon law, such as the qualification issue. Does that make any significance to what happens at the time of the dissolution? And I ask that because the very years in question are the years when the common law of England was first extended to Wales. But as a canon law for the province of Canterbury would already have been part of the law of Wales. i.e. 1535 to 47 embraces the years of the Flaxen Youth.
So, of the rights, and I have to be a little cautious because canon law is often, if a lot of cases say canon law, it's often used to refer to Roman Catholic canon law, and in older cases there are statements, for example, that canon law was never automatically enforced in England and Wales because it was always subject to custom to the contrary. As far as I can tell, the chancel repair liability has always been an obligation under the canon law, and should be no different in Wales than in England.
But
Other rights are
it's just on that, but it's canon law that was disapplied in part by custom.
yes, because it was always subject
Because
to
the canon law is the obligation to prepare the whole church,
yes.
which was disapplied in England by custom that it was very solid to chance.
And in London by custom that none of the church was repaired by the priest, and some areas of Norfolk. As for other right, I mean, the right to the chief seat and the chancel again is canon law. But the advowson of the vicarage was implied by the common law. And the freehold of the church and churchyard is a horrible mix of the two. And tithes is also a horrible mix because it's a matter of ecclesiastical or canon law, but where they had been severed, which they could be in some instances, the common law begins to make various inroads. I do not know what variations there might have been between England and Wales as regards things like the presumed advowson of the vicarage.
It just worried me whether or not there was any effect at the beginning, which might now be relevant.
Not to my...
I've never seen canvassed actually, so I'm going to put the dates.
The severing of tithes is post.
Not mostly post, but no, some of it is very old. So it became difficult to sever tithes after 1200, 1280-ish. I need to look up the date. But previously, it had been possible for a portion of tithes to have been granted to a religious house, and they could own a portion of tithes in a parish in their own right, not having taken the rectory. And it causes a bit of a headache in some of the 19th century case law, when people could prove the origin of where their title to tithes came from. To appropriation. That's the big thing. Again, if anybody knows otherwise, I'd be curious to know, but I have not found any decision by the court or an act of parliament pre a decision in the 20th century that altered or implies an alteration in the basic nature of what chancel repair liability was. So there is a conclusion, a tentative one, that it was and remains until this day a spiritual obligation on a person who's filling a religious office, albeit one that might be enforced. Well, we'll come into enforcement in a bit. But what definitely happened is that the rectoral rights became more fragmented, particularly getting towards the 20th century. And they also changed their nature because common land was enclosed between the 16th and 19th centuries, and rights over common land were replaced with grants of land, and some of those grants of land were given to lay rectors. And the right to tithes was incrementally abolished. The Tithe Act 1836 created a scheme for changing them into tithe rent charges, which are charges on land. And they were eventually abolished by the Tithe Act 1936, although it took nearly 50 years for them fully to disappear. Briefly, 20th century, there's two cases to look out for, apart from Wallbank, the two most recent cases. They're both a little bit nasty if you get caught with a chancel repair liability on your land. Wickenbrook, it had been thought that your liability to repair the chancel was a liability to use the profits from the rectory to repair it, and your liability couldn't outstrip the profits that you received. Wickenbrook said, nope, it's a personal liability on you. It's not related to your land. You get on with the repairs. And also said, well, if there's multiple lay rectors, because the rectory has been split up, each of you is individually liable, severally liable to repair the whole chancel. You can get a contribution from the others if you can, but if you can't, bad luck. Chivers and Sons, this is the case I mentioned, that the first one that really looks at the nature of chancel repair liability. It is only a High Court decision, and it is quite possibly wrong, we say in the consultation paper, but this one says that somebody who buys rectoral land that used to belong to a rectory, automatically becomes liable as lay rector. So that's the one that causes trouble for purchase of land. That doesn't really fit with how rectories were transferred in the past, where you find it's not the land that gets transferred, but the rectory. Someone takes a conveyance of a rectory and it carries with it everything that goes with the rectory. And somebody who just took a bit of land, it doesn't look as if they were held liable in the 16th century. But come the 20th century, Chivers says that they are. Right. Apologies. That's hopefully interesting, but a bit complicated. I want to talk about chancel repair liability in Wales. One thing I haven't mentioned that it'll be relevant to the what happened in Wales is that chancel repair liability was enforced by admonishment. You would go to the ecclesiastical courts and say this person has not done their duty, and the court, the chancellor of whichever diocese it was in, would admonish you to do your duty. And if you didn't, the penalty initially was excommunication, which was bad. But latterly, certainly by the beginning of the 19th century, it was being held in contempt of court. And so the penalty was imprisonment. So enforcement was much closer to a criminal sanction than it was to a civil action for a debt. It's one of the reasons why this liability probably isn't like an interest in land. It's more like a personal obligation on an office holder who is then punished for not doing what they should have done. The Chancel Repairs Act 1932 changed the law after a case in 1929 where a lay rector was committed to prison for failing to pay. That was Mr. Stevens and Hoxton Parochial Church Council. But the Act actually doesn't seem to change the nature of chancel repair liability. It says if before this Act was passed, you would have been liable to be admonished to repair, then the local parochial church council, if the chancel is in disrepair, can serve you with a notice. You've then got a time period to comply. If you don't comply, they can take you to the county court and they will get a debt, as if it were a debt claim, and they will get a judgment. But the Act doesn't say anything at all about the underlying liability. It doesn't say it's changed. It just provides an enforcement mechanism to be used, and at the same time says, and you can't go to the ecclesiastical courts anymore and get somebody admonished to repair. But I said Wales is interesting, and it very much is in this project, because the church in Wales became disestablished. Now, from 1920, when disestablishment took effect, Section 3 of the Welsh Church Act 1914 said that the ecclesiastical courts shall cease to exercise any jurisdiction in Wales and Monmouthshire, and ecclesiastical law shall cease to exist as law. I note, actually, we don't mention it in the report, there is a power to create a new scheme of courts, but they shall exercise no coercive jurisdiction. Now, before I think about the effect of that, a word about Wales and Monmouthshire. We had a very useful chat with the representative body about this. Section 9 effectively explains what counts as Wales and Monmouthshire, because there are parishes that fell partially in England and partially in Wales. Where that happened, the Welsh commissioners could determine whether the parish fell within the Church of England and continued to be subject to ecclesiastical law, or the Church in Wales, taking into account the wishes of the parishioners. And our understanding is that the majority of parishes opted to go to the Church of England. So that means that if we think about governmental Wales, the jurisdiction of Wales, some land in Wales is part of the Church of England. May still carry chancel repair liability. So matters are a little bit complicated when it comes to Wales.
Can I just, it all depends on whether this is a property right, so whether it's a right under the the property law, or whether it's an ecclesiastical obligation.
It does.
If,
Potentially.
if it were properly be thought about as a property obligation, then the World Church Act has no relevance.
That's right. If it's an obligation under the common law, or a right in property recognised by the common law, then the Welsh Church Act will have no impact. But in 1920, and as it was for the centuries before, it was still uniquely enforceable in the ecclesiastical courts. You could not take someone to the civil courts saying they haven't complied with their obligation to repair the chancel. It was only enforceable by admonishment, and we think, because we haven't found anything that would have changed it, that it was still an obligation under ecclesiastical law. So our tentative view, and I'm going to come into some court decisions in a bit, is that the 1914 Act, by abolishing the jurisdiction of the ecclesiastical courts and ending ecclesiastical law, ended chancel repair liability in parishes in Wales. Sorry, that's actually what this slide says. Let me go back one quickly. There's a bit of case law on this. There was a House of Lords decision between the Tithe Redemption Commission and the representative body. But before that, there were a few tithe cases, one of which went up to the Court of Appeal. The judgment's at the bottom of the slide. The Court of Appeal seems to accept that it's an obligation on ecclesiastical law and would have been abolished by Section 3 were it not for something that turns up later in the Act. So insofar as there is authority on this issue, and it's Court of Appeal authority, it seems to be that our view is right. This isn't mentioned in our CP. We'll have a look at it in some detail in the report. But Welsh Church Act, there was one uncertainty. There's this provision in Section 3.2. Again, thank you to the representative body for drawing our attention to it. It says that although ecclesiastical law has been abolished, the Articles, Doctrines, Rules, Rights, Discipline and Ordinances shall be binding on the members for the time being of the Church in Wales, as if they were contractual. The purpose of this was to stop the relationship between, say, parish priests and the Church in Wales immediately breaking down because ecclesiastical law was gone. It would continue as a contractual relationship. I had a query over whether a member of the Church in Wales might include a lay rector, because member isn't defined. That doesn't look to be what was intended by the Act, because the Act has a provision later on lay rectors, which would probably be inconsistent with that, because it's not clear why it would be needed if this applied. But there's some case law on it. Again, this is the same one that considers the meaning of the effective abolition of ecclesiastical law in Wales. Lord Green says that the section doesn't apply to lay appropriators. That members isn't to be construed that broadly.
My vision is that Church in Wales is free to determine who its members are, as we do in our constitution, and don't include lay rectors. At least that's my right. I'm nervous about supposition.
I agree with that entirely. But whatever the Act means, it empowers the Church in Wales to make rules and regulations for its own government.
Yes.
And it has done so and defines what constitutes a member. And if the lay rector was not a communicant of the Church in Wales, it would not be.
Unless a lay rector is a member by virtue of some other, meeting one of the other criteria for membership.
And they could fall outside of it. Member would not be bound by rules and regulations made of government.
That would be helpful if we have to fall back on it. Although I don't know if the interpretation of the Act could be given that it has proprietary effect on existing rights. I don't know if the Act should be interpreted so as to leave it to the Church in Wales to determine what the terms of the Act mean, and potentially then to change it.
Phrase members of the Church in Wales in the Act. What's meant by the Church in Wales? Does it mean what we currently mean the Church in Wales as a religious body in Wales? Or does it just mean what it was prior to this establishment? I.e.,
the members of the Church of England in the area subject to the Welsh Church Act.
Yeah, that raises the question of what's the name of the church.
As I read it, the second, but I don't know for sure. And the Act.
We can give that side.
I think we can say second is what's constant with other expressions in the Act.
That seems right, but these terms aren't defined in the Act, unfortunately, and it's being in 1914, it's published without explanatory notes, and okay, but for Wales there's a saving provision. Here it is. Nothing in this Act shall affect the liability to pay tithe rent charge or the liability of any lay impropriator of any tithe rent charge to repair any ecclesiastical building. So insofar as somebody was a lay rector because they owned tithes, and those tithes were changed into a tithe rent charge by the 1836 Act, so they now owned a tithe rent charge, and insofar as owner of that, they were still liable to repair the chancel, they're still liable despite the Act. And 20 years before the Chancel Repairs Act, there's a very useful, very succinct, nicely phrased provision that moves jurisdiction to the county court effectively in 2082. I don't know why the Chancellor's Repairs Act didn't just copy that. That seems nice and clear. So it looks as if potentially some chancel repair liabilities in Welsh parishes might have survived. But note the Act says nothing about any liability of someone who owns glebe land, nothing about anybody who had a parcel of land given to them under an Enclosure Act, which would have included the wall banks in the Aston Cantlow case. Nothing about any liability if it was possible to keep the rectory but sell the land. It doesn't say anything about that liability. And if we're right about the effect of Section 3, it looks as if all those liabilities were abolished, whether intentionally or not. Yes.
I don't need to speculate, Rob. You talked about the lack of case law through the 18th and 19th centuries.
Yes.
I've been trying to work out whether Section 28 was deliberate in restricting, in singling out tithe rent charge from other forms where repair liability may have arisen, those three on your list.
Yes.
Or whether those have effectively fallen into desuetude and lack of knowledge
At the time.
at that particular point in history, and they thought they were covering all chancel repair liabilities by speaking of tithe rent charge. I'm just trying to think, are you aware of any popular knowledge of chancel repairs being enforced on the basis of Enclosure Act rights or others around the time of the drafting of that, which is essentially the...
I'm aware that a number of the cases that I've looked at from 1850 through to 1900 are tithe cases where the entire property of the lay rectory was tithes.
I can't think of any Enclosure Act.
I would need to look again. Off the top of my head, I don't know. But I do know that the Wallbacks was an Enclosure Act case.
Section 28 is really odd.
Yes, it is.
Just in general,
and
specifically singles out.
And there's not an absence of case law on Enclosure Acts from the early 19th century, either, from memory. I'll get back to you if you like. I'll have a look and see if any of... I have a list somewhere. But it is true, the emphasis was... There's a lot of cases that only mention tithes towards the end of the 1900s. Sorry, towards the end of the 1800s. Right. There's one more wrinkle now, because even if some people owned a tithe rent charge in a Welsh parish and they were still liable for chancel repair liability as owner of that tithe rent charge, which is a bit of an if, then comes the Tithe Act scheme. Well, I'm going to go back in past, but we're going to get to the Tithe Act 1936. So the Tithe Act created a scheme for getting rid of tithes, replacing them with tithe rent charges. Section 71 says your estate and the rent charge will be subject to the same liabilities and incidents as that in the tithes, and that anybody who's got an interest in or claim to any tithes or charge or encumbrance upon any tithes, which might include the church or the church wardens or the diocese, will have it in the tithe rent charge. This is generally understood to have preserved chancel repair liabilities. It's a little mucky. We talk about it a bit in chapter 4 of the consultation paper, but assume that keeps the chancel repair liability going with the tithe rent charge. The Tithe Act 1839, well, first of all, there was provision under a number of Tithe Acts just to buy out the tithe rent charge, which would extinguish it. those acts did nothing to preserve any chancel repair liability. So where that happened, it looks like the chancel repair liability just disappeared. Section 1 of the Tithe Act 39 allowed you, in very rare cases, if you owned the rent charge and you also owned the land which was burdened by it, to merge them. And the rent charge would disappear, but it said that when that happened, any charge, encumbrance or liability that affected the rent charge would become a charge or encumbrance on the land that it had merged with. In our consultation paper, we say we're not actually sure that Section 1 applies to chancel repair liabilities. It refers to charge, encumbrance or liability on land. It seems to be looking at financial burdens on land because it then talks about whether they have priority to other charges on the land. That terminology doesn't seem to fit chancel repair liability, and we haven't seen any sign that the 39 Act was really meant to deal with chancel repair liability, particularly given the later acts say nothing about it and apparently extinguish it. So we don't think it's obvious that merger of tithe, rent charge and land preserved chancel repair liability. That looks up in the air. There's no case law on that topic specifically. So then we get to the 36 Act. The 36 Act abolished tithe rent charges. If they carried a chancel repair liability, that was also abolished. It's just the person who owned the tithe rent charge got government stock to compensate them, and if they had a tithe rent charge, some of that stock went to the representative body or to the church commissioners. So that's most tithe rent charges when they were abolished in 36. Chancel repair liabilities went with them. There is a very slim possibility that some chancel repair liabilities survived. So various ecclesiastical and educational bodies retained their liability. So they got all the stock, their liability didn't go away. This is only named bodies, it isn't landowners in Wales. We're not looking at 31(2). It didn't affect the liability of an owner of land if their tithe rent charge had merged under Section 1. So whoever wrote the 36 Act thought that the 1839 Act preserved chancel repair liabilities, and if they did, it said they should continue on the land. I'm not sure that that's what Section 1 did, but in any case, the Welsh Church Act came after this. So if you've got a chancel repair liability from merger in 1920, it looks like it was killed by the 1914 Act. And finally, if you owned the tithe rent charge and the land burdened by it in 1936, when the Act was passed, they merged, and the Act says the liability then transfers onto the land. So it's a question for Wales. Does chancel repair liability still exist as a burden on land in parishes in the Church of Wales? That looks like it's the only way via a merger. And it looks like it would have to be a merger either between 31st of March 1920 and 2nd of October 36, or under the Tithe Act at the point that the 36 Act was passed, and only for people who during that time owned both the rent charge and the land burdened by it. And that's only if Section 1 of the Tithe Act does preserve chancel repair liabilities, which we don't think it does, but it might do. So the answer to that question is technically maybe, quite possibly not. We would be very keen to know if anybody has encountered a well-established chancel repair liability on land in a Welsh parish. But the possibility of it still existing seems very, very slim. Right, I've been going on for a little while. I'm going to be quite quick on this. One reason for coming to Wales is precisely to ask about that, because Wales does seem to be different to England. The scope for it being chancel repair liability being a burden on land in Wales is very small, we think. But in England, it certainly still is, and the Land Registration Act applies in both England and Wales. So in our report, we've provisionally proposed an amendment of the Land Registration Act to help clarify that chancel repair liability can be registered, and if it's not registered, it doesn't bind a purchaser of land. The worry, to summarise, is that despite the Land Registration Act, a person who owns rectoral land is therefore possesses the office of rector, because of Chivers says you automatically get the office with the land, and consequently, as an office holder, is bound by a personal obligation to repair the chancel. The personal obligation is not registrable under or subject to the Land Registration Act. And so if they sell the land to person B, which transfers the land, and there's nothing registered against the land, the worry is that the office automatically follows with the land, although it's not registered. And sorry, let me click that one. Consequently, the personal obligation is owed. That's the worry. Might not be right, but that's the doubt. And we are trying to resolve it by adding a bit to the Land Registration Act that says, if you're under a chancel repair liability, for the purposes of this act, it is an adverse right affecting title. And because if it's a personal obligation, rules of priority might not apply to it, we go on and say, if section 9 is applied to it so that the liability is postponed, what that means is you're not subject to the liability. And we've proposed backdating, applying this retrospectively on the basis that this is what people thought the act did, that nobody is likely to have acted on the basis that the act didn't apply to chancel repair liability, and so it shouldn't prejudice anyone to backdate it. But prejudice is a question of fact, and we're very keen to hear from church bodies about whether retrospective legislation in this instance could prejudice them at all. I've gone over by 5 minutes, but thank you. That's the presentation. Lisa, do you want to say hello to everyone, and then we can do some questions? Come and grab my chair, because then you will also potentially be on camera if I stop sharing my screen. There we go.
Let's prove I was here. Hello, everyone. Well, thank you very much, Chris. We're delighted to be here. Thank you very much for being willing to host us. Thank you to Keith. Thank you for everything that you've done to allow us to be here. So over to you, really. As Chris has indicated, and Chris is obviously the expert in this area in terms of the Law Commission, we're very keen to know where we could be wrong. We're very keen to know what we don't know, if you know something we don't, and whether that makes any difference to the direction that we're going in. Obviously, the consultation is currently open, and we're hoping to get as many responses as possible so that we can frame our final report appropriately, and hopefully address this once and for all, having thought we did that last time round and maybe previously as well. So we'd be very grateful for any thoughts you have, any questions you have, and any evidence you think that you have that we're not right in our thinking at the moment, or wait to suggest that we might be. So over to you. Thank you.
So if you don't have any questions for us, I'm going to have
we
some
have questions for you, but
Let us ask the bit at the end, which we went over quite quickly, as it were. So,
yes, we can.
Your suggested solution is, to make it necessary for a chancel repair liability to be notice of it to be registered, if it is to be binding upon a bona fide purchase of a land.
Yes.
So that doesn't differentiate between the position of Wales and England. Any thought in given to sort of simply saying, for the avoidance of doubt, Welsh Church Act 1914, as a result of Welsh Church Act 1914, chancel repair liability does not exist in relation to Wales?
We're giving thought to that now. The project isn't about the terms of reference of the project aren't on the looking at reforming the nature of liability. So, for example, making it cheaper or dividing it up or abolishing it. Our previous project in the 1980s recommended abolition. Government rejected it in 98. That said, it is very different abolishing a liability in England that we know still technically exists and saying we don't think it exists anymore in Wales. So there might be something we could do in Wales. I don't know what it is. We would have to talk to our sponsoring department, the Ministry of Justice, and commissioners. But it's worth considering. And of course, there are gradations of things we can do in the report. We can have a recommendation with a clause in a bill. We can have a discussion in the report that suggests government look at it. We can just mention it and try and drum up moves for either Welsh government or Westminster government to look at.
The border parish is a problem from our previous discussions, that you can't draw a line saying land situated in Wales is not subject to Chancel repair liability because there are small pockets which potentially are. And that actually possibly goes beyond what we traditionally understand to be the border parishes, because there were some non-contiguous, there were some exclaves deeper into Wales that were part of a parish that's now in the Church of England. So it'd be quite difficult to draw a map for conveyances to demonstrate what was, what isn't subject.
We
I've had an idea on that. So.
As far as legislation is concerned, we would have to talk to Parliamentary Council. It would, I think, be quite easy to abolish Chancel repair liability if it was something we were doing in Wales that only affected parishes of the Church in Wales, probably just by cross-reference to the 1914 Act. But it wouldn't be very user-friendly because anybody who read the law wouldn't know where it had or had not been abolished. But as far as user-friendliness goes, if you can't do it in the legislation, that might be something that could be done in guidance or. Anyway, sorry, you had an idea.
Given the tiny fraction of such Chancel repair liability as might have traditionally been assumed to exist, and therefore conveyances requiring searches relating to this tiny border parishes issue, it's going to affect a very, very small number of English PCCs if we're dealing with civilly in Wales. Legislation that requires a notice on the title for enforcement even against a current owner with a sunset period. So would give those English parishes with Chancel repair liability in civil Wales opportunity to protect their position, and thereafter abolishing the liability, including against current title owners, would then mean at the end of that sunset period, anybody buying or selling property that's within the civil jurisdiction of Wales would know that it's not affected by the Chancel repair liability.
Which would be a technical abolition.
Yeah, well, yes.
Which is perfectly within our.
We would abolish it, and it would be abolished as relates to the Church in Wales, and it would be a technical abolition of liability as relates to the Church of England within the civil jurisdiction.
Yeah, I think that would be the tricky bit within the terms of reference.
That would be the tricky bit. It doesn't. That's not to say don't write it down.
No, absolutely, because it can be reflected in the report as a were it to look like one of the more simple solutions even though we don't have a remit for abolition, doesn't mean that it can't be discussed as this might be a more effective way of addressing a complicated problem.
That's true, because, I mean, you might even do it more directly.
Yeah.
If government was pursuing abolition, they could talk to the parochial church councils along the border and say, do you mind?
The difficulty will be working out those parishes to talk.
Yeah.
It's not necessarily the ones which are subject to the border laws, and it's not necessarily the ones immediately adjoining the border, because some of the exclave issues should take a lot of research. Might be possible.
Yes.
Fabulous PhD.
On the terms of reference, you say that abolition is outside.
It is.
Going back to what Keith, I think, was suggesting earlier, would clarify in legislation that it had been abolished by the 1914 Act be outside the terms of reference?
Well, so that's a really interesting one. There is quite a difference between us saying, if there is sufficient evidence for us to be able to say it, it appears this does not exist and here's the evidence. But it might be safer for the avoidance of doubt for that to be stated in a way which is clear. And one could do that in legislation, would be different from us saying either, one, we recommend that legislation says this, or secondly, us actively seeking to abolish, which we are not permitted to do. It's a question of how robust is the evidence to allow us with sufficient certainty for the 5 commissioners to feel that they can say, yeah, there's enough evidence here to say that it doesn't exist at this stage in a particular context.
One thing that might influence that would be the views of the representative.
Yes, absolutely.
As far as enforcement of child welfare liability on land in
That's from this, because you're not saying it's all been abolished. You're saying that it's been abolished to such an extent that it's technically possible that there are pieces of land that are subject to it.
Yeah, if we were to say,
but we don't know if there are any, and if there are any, we don't know where they are.
but we do know that there won't be much.
many.
Yes.
So if we, as the landowners, say we have no intention of researching or enforcing those,
Yes,
that would be of assistance
yes.
to bring us within your terms of reference.
And it would only need to affect somebody who was liable because they owned land and rights.
Because the only practical thing we're interested in preserving is in the institutional liability.
Lord Christ College to start.
We probably, yes.
Yes.
I won't name individual colleges, yes, but Oxford and Cambridge colleges and possibly the Church Commissioners for England in correspondence about. Those are retained. I would think that we may be able to do that. It leads me to the other difficult question. There may not be an answer to this. My understanding is that when a parish church is closed in the Church of England, there is specific statutory provision that liability to maintain its chancel lapses.
There's case law on it if there's not.
That's going to be my next question is, because we've had to post this establishment legislation that we're not subject to, are we sufficiently clear that there are no other landowners who might conceivably claim the benefit of a chance of repair liability on the basis that they are redundant Anglican churches that we have disposed of? Now, there's a separate question as to who is entitled to enforce them, because section, depending on section 28 of the Welsh Church Code would apply there. But if you're content that once the church is closed for church and Wales worship, that the liability lapses, then there is only one landowner, the landowner that is concerned as owners of the churches.
Who would it concern if it didn't lapse? So are you thinking that if there was a church of the Church of England in Pembrokeshire in 1800s?
I'm more thinking that
Yes.
I'm more thinking I bought a church.
Yes, I bought a church, I converted it into flats, but you know,
Oh, I see.
but the area, but the nave, yeah, the chancel is still there
Yes.
as part
Still
of the
physically there.
scheme. It's still there. So as the person who owns that, I've sold off all the other land that was round it was parcelled
Oh, I
off.
see.
So I don't have all of it. Can I get money from all of those landowners in order to be able to help me with my
Yeah.
rather beautiful?
We would need to think about it, but no, no, in no way.
I mean, that's
I confidently say no.
In which case, it would be the church.
Yeah, I mean, as it happens, there's a decision of the King's Bench division. I think it's King's rather than Queen's. I think it's in 1812, called Townsend against Clifford and Wicks, where the Lord Chief Justice is considering whether lay rectors can sell small plots in the chancel for people to be buried in. And they say no, a lay rector is incapable of transferring away the freeholds of the church. The freehold of the church is an essential, inalienable part of a lay rectory. For some reason, although it's quite a high authority, that case seems to be entirely forgotten. But it's not overruled. It's not mentioned in Wickenbrook and Chivers. Nobody cites it to the court. So when Chivers came along with Chivers and Sons, who bought a bit of land and said, "We're not lay rectors. We bought it from the Queen's College, but Queen's College is still the lay rector." Nobody asks, well, who owns the church? But
I've never seen any authority for the 10,000 plus parish churches that were registered with the land registry in the name of the incumbent,
yeah,
as opposed to the lay rectors.
Well, and does the chancel cease to be a chancel when it ceases to be?
well, there is a case there where a claim to enforce transport pay liability is dismissed because the court says, no, the church is a ruin and it's been a ruin for 70, 80 years. No, this is no longer there's no longer a parish here that's using this as a parish church. It's gone.
That's probably the answer.
That would probably cover it.
So it's not used for worship.
I can't remember what level. Yeah, not used.
Yeah.
It hasn't for
Oh,
some
right,
generations
yeah,
been used
then.
for worship. But I can't remember what a level of authority that case is.
So that leaves, taking all these off, that leaves the Friendless Churches, which is the Welsh, sort of the Welsh Church Conservation Trust, who had they're not freehold owners, they only have a 999-year lease. Right?
But being the freehold owner wouldn't give you the right to enforce.
No.
It's a little bit difficult.
Yes, because they are holding churches sort of in aspect, as in they are a historical trust.
So they might be enforced against.
But permit the terms of the lease are permitting continued occasional use for worship. It's no longer a parish church, but it is still a church where regular worship takes place. We may need to speak with them. Those are still Anglican churches. They have the maintenance responsibility. I can't imagine it's going to be an issue, but
Are they not though within parishes of the church in.
They're with it, so they are, but they're not. So yes, they are.
So unless they're part of the Church of England, an enclave of the Church of England.
Yeah, that's
I think section 3 is, insofar as the
section. Yes, I'm still circling along the infinitesimally small possibility. If there is a possibility that
yeah,
let's just say there's 6 acres of land across Wales which satisfies all your criteria for still being an enforceable liability. There's only 2 bodies I can think of who could seek to assert those rights. Definitely us, and we can get our position clear. I think we're happy that private owners who are not using them as own places of worship are covered.
Yeah.
By the case was that just by process of elimination, the only other body I can think of. Yeah, absolutely.
I don't know what would give them the right to enforce.
Yeah.
This stuff was enforceable in the ecclesiastical courts. A very wide range of people could come along and enforce. The patron, the bishop, the parishioners, the church wardens. Traditionally, the church wardens would do it, but I'm not sure if there was ever such a thing as a right to enforce.
It's a representative body solely given the right to enforce.
Yes, it is.
Actually, isn't it?
So I think it's you, and not you personally.
That's it. That makes it easy.
Yeah. I should say I'm also interested if anybody has a experience of conveyancing and making decisions about whether or not you take out insurance and what factors would influence you one way or the other.
I do have experience of conveyancing, yeah. So we tend to we basically always take up search as a matter of course, no matter where the property is, because there's this residual risk that we can't discount that may still exist.
Do you mind me asking what the cost is usually?
It's very low. It's one of the cheapest searches. I think it's £30, £40, something like that. As a basic check, and then to be honest, if this is in a commercial context, so commercial land, not residential land, if a search indicates there might still be residual liability, we would explain to the client that there is a risk and it's possible to insure, especially if it's in Wales. We'd say, without going into the detail, we think the risk is incredibly low, but nonetheless there is a risk, and you have a decision about whether to insure or not. And usually a client will take the risk and not insure, even though the cost of insurance is low. And that's usually the way it goes. But occasionally insurance is taken out, but not very often. But we tend to do the search in every case. Probably to deal with residential purchases tend to just take out insurance.
Non-search insurance.
Yeah, without even considering it as a matching course, because the cost is so low. I think that's even lower than the search cost.
Yeah.
But typically only for, I think it's only for residential, typically available at that low cost. So that's how we tend to do it. But yeah, it's not something we spend a lot of time on, to be honest, because the risk being perceived as probably is so low, and the cost being low. So yeah, but it's something we have to think about on every transaction.
We are thinking about how the law could be either clarified or changed in a way that would make searches and insurance redundant. I suspect that nothing we did to the Land Registration Act would immediately make a difference. It would filter into conveyancing guidance, put out by the Law Society and others, and it would eventually make it down into practice.
I think that's right. But I think the issue is the land registry guidance is quite an issue. But,
yes.
When I saw that, I immediately thought, well, that would solve the problem, because I could see sorry, no, it's not that, is it? It's just the suggestion. Oh, no, it is that, sorry. Yeah,
Yeah.
it is that. So, yeah, I immediately saw that we can see that then if we have a clear search and we're doing a purchase for value, I can see that then we have our transaction would take priority to any notice. We could be certain that there wouldn't be liability, and then we could just base our decision on the register. If there's no notice, we wouldn't have to take out search or insurance.
We thought initially when we took the project on that there might be nothing here. We might be able to put out a very short paper that said, oh, we don't understand that Land Registration Act clearly applies to this liability, which Land Registry might then act on and change their guidance. As it happens, we think the law's pretty unclear. We could be wrong, but whether we're right or wrong, it definitely seems to be unclear. So it's very difficult to say to Land Registry, you're quite risk averse, you should change your guidance without a change in the law. But we hope that something like that would mean Land Registry would take off the caveat from their guidance, and that then will filter down to professionals. I know previous versions of the Commencing Handbook have referred to insurance. I think the newest edition doesn't, but hopefully it could also influence the Conveyancing Association and other professional bodies. Have you had many cases where your search has come back with a possible?
Yes, that's happened quite a lot. I'm thinking now in Wales, it still does come back with a potential liability occasionally. Obviously, it does in England as well. Yeah, so it's quite frequent actually, but I don't know to what extent the search is based. I'm not really privy to what the search is based on, so we just we take it as it is. Yeah.
As I understand it, all the search is doing is indicating whether the land falls within a parish or district that either had a record of ascertainments under the 36 Act referencing land or an enclosure act. For a while, the search companies weren't very good even on enclosure acts. I don't think it's doing anything more site specific than that, as I understand it. I may be out of date on that. Could be years since I was looking at it in private practice, but
that fits with our understanding before. Which, I mean, in effect, might as well check on the age of the church. Yes, I don't, but there's more than one service. I don't know whether any use different methods. How much, when you've taken out insurance, what sort of prices do you get for commercial land?
Well,
We don't really.
I couldn't tell you, to be honest, but it's so infrequently done. Can't think of anything the last time I did it, but my memory is that it was very cheap. Still, I think it's probably because we'd be doing it in a situation where we've obtained the search, so that shows a potential liability, so it's more expensive in that situation than it would be in the residential context I mentioned before, pre-search. But I don't think it's very expensive. So
Yeah. But more expensive than the residential.
I think so. Yeah. I think it's more expensive than the search itself. I think, but again, it's not one of the more expensive indemnity insurances.
Yeah, and presumably you've never encountered a case where there's not just a potential liability, but there's a liability and someone's been sued.
Well, unfortunately.
back in the days when I had some instructions from PCCs when I was private practice, and I can understand why commercial insurance is more expensive because just reputationally, there are a few parishes thinking they would never dream of enforcing against a homeowner because of war bank, but actually they wanted to research the position because they were like, well, if there's some commercial land,
Yeah.
we can go against insert company of choice rather than insert individual homeowner of choice. Like whether it's actually being pushed to seeking contributions on, I can understand an insurer's position on that. Then commercial would be more expensive. But I think if the liability exists, I think parishes were more likely to enforce.
We did get some information from insurers pre-project, which looked, well, from that particular insurer, they're a big insurer, suggested that a lot of their policies for commercial land are in the region of 50 to 100 pounds, but might be more expensive if it's large or if there are particular risks. But it does look as if the insurance product is effectively funded by people buying insurance in areas where they couldn't possibly be subject to the liability. And certainly in cases where there's nothing registered on the title. It actually, one thing we will need to consider is if everybody stopped taking out insurance, what will the few people who've actually got a chance to repair liability on their title do about insurance? Because will they still be able to get cover? But nonetheless, as a matter of principle, it can't be right that one group of landowners are funding another effectively. So we will have to think. I mean, as far as public expenditure goes, our impact assessment will presumably be neutral. We will be stopping a transfer of wealth from landowners to insurers. But that, as far as government's concerned, nothing's coming or going from it. Although the Crown might be interested, because we understand that parochial church councils are very much more ready to pursue the Crown if Crown land happens to be subject to transfer repair liability. Yes, is anyone else?
Can I go back to the categories that might give rise to chancel repair liability? We're not certain if there were any. Greed was one, I think.
The ones that weren't covered by the saving revision.
Yeah.
Yes.
Anyway, I don't think we need to go back. My question was, if you dealt with everything as a matter of interpretation of the statute, you didn't cover them. I wonder whether or not you thought we were going to the other end, and seeing whether or not anyone had paid for chancel repairs, and the basis of their obligation had lain in those areas, such as Greed. Because there are records, I think, I assume the records of the RP, but certainly in the parishes, of where contributions had been made by a proprietor, what the basis of their liability had been. Because quite often when they're asked to contribute, they would contest it. Certainly instances I saw 30 years ago was that they would only contest it, but payments had been made and they were recorded. So at Oxford College paying in 1924, when it had to in 47, agreeing to do so, and again in the 1950s. And the record was there. Possibly it also says why.
Some of our questions at the end of the paper are trying to get at this, particularly in England, where the Church of England doesn't have any centralised database. So we're reliant upon individual parochial church councils recording what has and hasn't been paid. Our understanding is that for landowners in Wales, it doesn't look as if any have paid for a very long time.
We're confident that there's no landowner in Wales that's paid this century. That's going back to the 20s, 30s, so forth. We probably have a record in paper, but it won't be filed in a way that's helpful. One would have to go through each parish's individual records That's a needle in a haystack job, which with our trustees are not going to give us the sort of resource to do. Borrowing that, I'm afraid. I will go away and think about whether there's any way.
The only one I've seen like that was, it was an Oxford College, they paid for a church, fairly near the border. It was a church.
We have had some information from colleges and ecclesiastical, educational bodies that are subject to the liability, saying that they still pay. I don't know whether they concede they're liable, but some of the ones we talked to want to keep paying. They see it as a part of their traditional and charitable function. But it's somewhat anecdotal because we haven't as of yet had responses from every college that might be affected. But yes, we do know that payments are being made now and again by
The ones we're aware of from institutions that have happened recently, by which in the last 40 years. We think the same by section 28, because it's the rent charge that was then compensation stock was issued to the institutions rather than being from one of those.
Any further thoughts? Or things you think we need to go away and look at?
Well, we've actually covered anything I would have asked you about. Except to say, if you have thoughts or views, please send them in, even if they are along the lines of, I had one case which I did where I've remembered it was quite expensive and we spent £120. Just as a one-off is useful anecdotal data, or if you suddenly think of a measure or a statute that we haven't looked at, there's certainly legislation we don't talk about in the CP. The Church of England has sent us a list. I don't think any of them make a difference to anything we've said, but I want to go through them carefully and have a look. But please feel free to send us anything. Certainly up to the 15th of November, but thereafter too. And as far as the representative body goes, we might want to chat to you as we're writing the report, possibly.
I think obviously we will be able to provide you a response to consultation. What I won't be able to do is get trustee backing for a decision that we would never enforce and support abolition, but that if when we finished our consultation response, we think that's something we can investigate, but that can forward to later date.
Okay, that might be useful. Aside from that, thank you very much for coming.